Hi, it's me, Dr. Paul Gerhardt, and in this video for labor relations and collective bargaining, I want to talk about the arbitration process. So here's some of the things that we're going to be talking about today. We're going to talk about types of arbitration, history and legal state arbitration, arbitration of statutory rights in union and non-union cases, selecting the arbiter, determining what you can arbitrate, and hearing about procedures, as well as case preparation, just cause, and arbitration issues in the public sector. All right, so let's start off by talking about what arbitration is. So, arbitration is a process in which the parties involved agree to submit an unresolved dispute to a neutral third party whose decision is final and binding. So there is interest arbitration, and in interest arbitration, this is a process used to resolve an impasse in negotiations in which the parties submit the unresolved items to a neutral third party to render a binding decision. So that's interest arbitration. Rights or contract arbitration is the submission to arbitration for the interpretation or application of a current contract that's been written and what the terms are. In the grievances cases, the arbitration involves the rights of the parties involved under the terms of the contract. So, demand for rights arbitration. Based on the wishes and needs of the parties, arbitration process is more private than public judicial proceedings, and it involves more sophisticated and knowledgeable parties than those in most judicial proceedings. So that's demand for rights arbitration. So, determining when to arbitrate a grievance. So, here are some of the considerations in arbitrating a grievance. The importance of the issue, the effect of winning, the effect of losing, possibilities for a settlement, psychological or face-saving aspects, and the merits of the case. So consider the Lincoln Mills case. Now, this is a landmark decision in which the Supreme Court ordered an employer to arbitrate grievances as provided for in a collective bargaining agreement, stating that an employer's agreement to arbitrate grievance disputes was a trade-off for the union's agreement not to strike. Then there's the Steelworkers trilogy. 3 1960 Supreme Court rulings that upheld the grievance arbitration process and limited judicial intervention. There are 3 issues that have evolved from these decisions. General arbitrability. This is grievance is presumed to be arbitrable. That's a hard word for me, as long as the contract provides for arbitration and does not exclude the topic under consideration. Number 2, expired contracts or changes in ownership. And 3, successorship. Successor employer are not required to adopt the substantive terms of the predecessor's agreements. So, in sum, the Supreme Court made it difficult to avoid arbitration if the contract requires the arbitration of grievances, acknowledged the superiority of arbitration in resolving labor management disputes under collective bargaining agreements. The arbitrator's role is not unlimited. The role is limited to interpretation and application of the contract. Alexander v. Gardner-Denver is a decided public policy exception to labor arbitration. And the court ruled that an individual could not be precluded from suing under civil rights laws just because his claim had gone through arbitration under the collective bargaining agreement. So that's important to know. Title VII cases. A grievant who loses an EEO matter in arbitration is entitled to take the matter to court. Wright v. Universal Maritime Service Corporation found that if a collective bargaining agreement arbitration provision clearly and unmistakably includes anti-discrimination claims, the court might require an employee to arbitrate such as a claim before resorting to the federal court. The Federal Arbitration Act and individual agreements includes 3 governing acts: the 1925 Federal Arbitration Act, or the FAA, the 1926 Railway Labor Act, or the RLA, and the 1947's Labor Management Relations Act, which is the MLRA. Another case of union and non-union cases here. So, Circuit City, Inc. v. Adams. Individual employees agreed to settle all claims against the employer by means of arbitration. The grievant filed employment discrimination lawsuit. The Supreme Court ruled that the complaint must be heard by an arbitrator. Employment arbitration agreements have increased as a result of the Circuit City ruling. The Green Tree Financial Corporation, Alabama v. Randolph. So the court ruled that a party seeking to avoid an arbitration agreement must demonstrate the likelihood of prohibitive costs, not just the possibility. Selecting an arbitrator. So labor and management have a hand in the selection and compensation of an arbitrator. The arbitrator's jurisdiction involves the collective bargaining agreement. Most arbitrators are selected on an ad hoc basis, when they need one, and sometimes work as a permanent umpire to resolve disputes for the life of a contract, and it helps provide a stable union management relationship. It really is important to find a truly impartial agency. And so you could do that through the Federal Mediation and Conciliation Service or the American Arbitration Association. So here's your steps for selecting an arbitration. Step number 1. At request of parties, tribunal sends a list of proposed arbitrators. Step number 2. Parties are given 7 days to study the list, cross off unacceptable names, and then rank the remaining names. Step number 3. Additional names are submitted to parties if none are found mutually acceptable. And step number 4, if parties cannot agree on a mutually acceptable name, a tribunal will make an administrative appointment. So here's the role of the arbitrator. They must follow contract language when the intent of the provision is clear. When the language is ambiguous, the arbitrator must interpret the provision in the question. Maybe you've done case studies where you've practiced doing exactly that. So, interpretation of contract is guided by basic principles. Honor the intent of the parties, interpret the agreement as a whole, give effect to all terms of the agreement, give undefined terms reasonable definition, avoid absurd results by considering reason and equity. A well-reasoned arbitrator's opinion may become part of that contract. So, the arbitrator's award is the arbitrator's decision in a grievance case presented in written format, and then it's signed by the arbitrator. Arbitration services include the Federal Mediation and Conciliation Service. The Office of Arbitration Services maintains a roster of qualified arbitrators, provides parties with a list of arbitrators, and then appoints arbitrators following selection by the parties. So qualifications of the arbitrators are not required to have any specified educational or technical training. and they have a variety of backgrounds. Some of the variables that affect the arbitrator selection include visibility, past arbitration decisions, and then use of procedural interactional justice methods. Some general qualifications include impartiality, integrity, ability and expertise, and then specific legal training. A tripartite arbitration board is an arbitration board that's composed of one or more representing management, an equal number of representing labor, and a neutral member who serves as a chairperson. So, arbitrability. The challenge of whether a dispute issue is subject to arbitration under the terms of the contract. If one party challenges arbitrability, the courts may get involved, may grant an injunction, may issue a court order to arbitrate, and arbitrability may be considered if an arbitrator's award is submitted to a court for review. The arbitrator may rule on question of arbitrability, and also there's something called double jeopardy, and that's a concept borrowed from criminal law for the principle that a person cannot be punished twice for the same offense based on the same conduct. So that is the same type of thing that happens when things are going through the arbiter process. So hearing procedures: an opening statement by the initiating party, then an opening statement by the other side, the presentation of evidence, witnesses, and arguments by the initiating party, then comes the cross-examination by the other side, the presentation of evidence, witnesses, and arguments by the defense, then there's a cross-examination by the initiating party, summation by the initiating party, which is optional, and then a summation by the other side, which is also optional, and then filing the briefs, which is optional, and then the arbitrator's award. So it sounds a lot like what happens in a regular court case. So in order to prepare for your case, you must make sure you study the grievance statement and review the history, examining the initiating grievance paper, review the collective bargaining agreement, assemble the documents, plan arbitrator trip to the place, and then interview all witnesses. You must make a written summary of witnesses' testimony, study the other party's case, discuss the case, and then do a sufficient amount of background reading. Some of the things that are arbitrated include seniority, promotion and upgrading, layoff, bumping, recall, other types of seniority situations, working conditions, discrimination, management rights, scheduling rights, work assignments, economic wage rates and pay issues, overtime pay, fringe benefit issues, health and welfare, pensions, other fringe benefits, discharge and disciplinary issues, technical issues like job postings and bidding, job evaluation, job classification, scope of agreement, subcontracting, jurisdictional disputes. Just cause is a contractual issue that we should talk about, and that's sufficient or proper reason for which management has the right to discipline or discharge employees with adequate warning, prior investigation, evidence, equal treatment, reasonable penalty, rule of reason, internal consistency. Interest arbitration violates principal bilateral settlement of collective issues, which discourages parties from making concessions. They frequently award a compromise between parties' final positions, and proponents believe this is an incentive to negotiate. So, finally, rights arbitration. is another public sector arbitration, and that's the authority of the arbitrator in rights arbitration is limited by the terms and conditions of the collective bargaining agreement. Okay, so I've covered a lot of terms, cases, and history in the arbitration process. Hopefully you've found some of the things here interesting and usable in your world. Again, not everything is going to be so clear-cut, but finding a way as a human resource professional to make sure your managers are doing the right thing and your employees are doing the right thing, and then recognizing the processes that are available. Not always so easy, but that's why HR people make the big bucks, right? All right. Hey, thank you so much for your time watching this video. I hope that you've taken something away from it. And even more importantly, I hope that you have a great day.